I think that the view of a lot of mothers that I speak to through social media groups, through the work that I've been doing with the Survivor Diaries, the difficulty that they're seeing is that the abusers get contact with the children, the abuse then continues through those child arrangements, and you'll find that those court cases keep going back to court, because there is an underlying problem that hasn't been remedied by the court, which is that the abuse is just being allowed to continue through the child arrangements. And again, see my other video about my messages to the family justice system. Hello and welcome to this episode for the Survivor Diaries. Again, this is one of a two-part series. It's two messages that I want to deliver. One is to the family court system, to the family justice system, and the other message is to the family court user. Both of them will include my observations, which may be maybe a little bit harsh or direct. And I'm hoping that my my perspective as both a court user and a professional is not going to actually end up with me offending both groups of people. However, I think that they both need saying, and that's why I'm doing this double episode. So the first one, this episode is going to be about my messages for the court user. I strongly advise that if you are watching this, that you also watch my message to the family justice system. This is because the message to the family justice system will cover probably a lot of things and your concerns about the family justice system, which I'm hoping that I'm going to be pointing out to them as well. Okay, so the purpose of this very brief episode is what I want to show you, what I want you to help you to know is about what the courts should do in domestic abuse cases where domestic abuse has been alleged and there's child arrangements proceedings, and I want to give very brief information about a mechanism that is in place. And because I'm speaking to court users, I know I'll be speaking to a lot of people who are well aware of the fact that the system has gone slightly wrong. Another thing that we're going to go on to within this is to understand why the family justice system is getting this wrong, what it is that the family justice system is doing, and also something that I see that the court user may be doing that doesn't help them in their own proceedings. And from this, what I'm hoping that you'll be able to do from this episode is to know how best to deal with and approach the family justice system if there are child arrangements proceedings, and especially if there's been domestic abuse within the adult's relationship. So first of all, coming back to this perspective as a court user. Well, what's happening in the family justice system? I am a member of the family justice system, and it causes me quite a lot of embarrassment. I don't know if embarrassment is the right word. I've described in a previous vlog where I've been to a conference, we went round and introduced ourselves, and there were many court users there, and when it came around to my turn and I said that I'm a family lawyer, it's difficult because the family justice system is getting quite a bad rep at the moment, and possibly with good reason. I think that the view of a lot of mothers that I speak to through social media groups, through the work that I've been doing with the Survivor Diaries, the difficulty that they're seeing is that the abusers get contact with the children, the abuse then continues through those child arrangements, and you'll find that those court cases keep going back to court, because there is an underlying problem that hasn't been remedied by the court, which is that the abuse is just being allowed to continue through the child arrangements. And again, see my other video about my messages to the family justice system if you can understand what I'm referring to there. The abusers are getting contact somehow when we're going to court, and I want to talk in this episode about why this is happening, what the family justice system is doing wrong, see the episode about that. In this episode, I want to help the court user to be the perfect client, the perfect court user, and how best to approach the family justice system. So I want you to be able, after watching this episode, to know the best way to approach and deal with the family justice system if there has been domestic abuse and child arrangements in your situation. Every case is unique, and you need to understand this mechanism. Should engage. However, there are several reasons why it might not engage. So it might not engage if, for example, the domestic abuse element has been previously considered. There's an issue if you've had contact occurring since the domestic abuse, because then of course the courts will immediately leap on that and say, well, the contact seems to be safe, and then they don't quite pick up on how that contact, which, as I keep saying throughout these videos, is just being used as a means of continue the abuse of the mother and the control of the mother and the unpleasant texts about handover, about the child's clothes, and it's a constant ongoing abuse. I've mentioned before about the fact that for 15 years I was experiencing this. My daughter had contact with her father for 10 years and not for the last 5-6 years, and she's doing much better now. And when she was having contact, it was a constant stress that I only see how significant that stress was now, after a serious breakdown, for want of a better word, in November, and now medication, which is taking away that stress and showing me how much I've been under stress over the last 15 years. Okay, so there's a mechanism in place. This is the practice direction 12J. And it's not just the practice direction 12J that many people going through the court systems in the last 10 years may have vaguely met and been told that, the courts may look into that. It's actually a much more revised version, much more recently revised version. It was revised at the end of 2017. And it was revised after a project called the Cobb Review. And this is where Mr. Justice Cobb actually looked at the problems that people were having with domestic abuse and child arrangements, looked at the old existing practice direction and realised how it needed to be modified. And his modified version, his revised version of practice direction 12J has much more teeth. It's much more robust. And the first piece of advice to the court user, especially if you haven't got a solicitor or if you're just starting out in the proceedings, is to know that mechanism. Put it into Google, practice direction 12J, have a read. And then once you know that mechanism, if you're talking to a solicitor, to CAFCAS, to a judge who doesn't seem to be following that mechanism, then show them the practice direction and explain what you expect to be happening. See again my messages to the family justice system about this. I've mentioned that there's some incidences where the practice direction may not be applied, or it may not engage within the proceedings. Some examples may be that the abuser has already made acknowledgements. The domestic abuse may have already been considered in previous proceedings, in which case the court would need to be looking at more recent harm to the children, and because domestic abuse continues through the child arrangements, that'll be there somewhere. As well as that, if you've had previous applications, consider whether it was before or after the end of 2017, because if you are coming back to court after 2017, remember to look at the practice direction and see how things have changed. One of the other difficulties that happens quite often for the court user is that contact has started happening already, and I'm going to come back to that within this video in a couple of minutes, but the contact may have already been happening, and because of that it persuades the court, makes the court have the view that the domestic abuse can't be that serious for the mother to be allowing the contact in some form. The domestic abuse may not be considered relevant to the arrangements. I would categorically disagree with that. Or that domestic abuse can be historic, again, because domestic abuse always continues to the child arrangements unless there has been genuine acknowledgement, acceptance and progress on a domestic violence perpetrator programme by the abuser. So what is it that goes wrong for the court user? First of all, we're looking at somebody who has come out of an abusive relationship. So if you're approaching child arrangements proceedings and you've just got out of an abusive relationship, you need to understand that you're probably, even if you're managing to not feel it because you've got children to look after, but you're probably feeling very vulnerable. You are abused. As a parent, there may be some direct hits in how the abusive personality is criticising your mothering, making you feel like a bad mother for leaving, making you feel like a bad mother for stopping the contact, how dare you, when you know that that contact is unsafe. And you may be receiving threats from the abuser about how you're breaking the law, and you'll be taken to court and then you'll be told how it's going to be. And this causes a fear and anxiety for the mothers, and yes, I am being gender specific. Just look at Pat Craven's Dominator. I'm talking about the co-parenting relationship and the predominance of domestic abuse, which is from a male to a female. That's not to say that I don't understand that it occurs in same-sex relationships or the other way round, etc., etc. So as the court application approaches, the mother gets even further distressed receiving an application, because remember, you will know this if you're a court user and you're a subject of abuse. Remember Pat Craven's Dominator. This is a liar, a persuader, a head worker. And so you've received an application basically full of lies. And it makes any mother feel defensive. Parents will always feel defensive in Children Act proceedings because they will both feel like they're on trial, because they are on trial, because their parenting is being looked at. So they're already feeling defensive. And when you're working with a mother who is coming out of such terrible abuse, and that has been affecting the children, it's a confusing time, it's a frightening time, and that's how she is approaching the court proceedings already, with a lot of fear. I speak to a lot of mothers through social media. I work professionally mainly with people experiencing domestic abuse, so I see the same patterns over and over again. The same fear and threat of court proceedings being used, and then this very, very fearful mother who then receives an application full of lies. The next thing that's going to happen is CAFCAS are going to be in touch. CAFCAS are going to be looking at this from a, well, why isn't contact happening? And I've said this before, it's a bit of a wild card here. Sometimes you get a CAFCAS officer, understands the practice direction, sees the allegations of harm, and in their initial recommendations to the court will say that interim contact can't really be advised until the court's made findings. Brilliant. As I said, it's a wild card. 50% of the time CAFCAS are saying that. In my experience as a solicitor, 50% of the time CAFCAS officers are misunderstanding domestic abuse completely, saying that the parents are in conflict because she says he's abusive and he says he's not abusive. And that's seen as conflict between the parents, which will be having a terrible effect on the children. And that's not fair at all, because it's impossible to co-parent with an abuser. It is an entirely different situation. High conflict parenting is not the same as trying to co-parent with an abusive personality. So CAFCAS, and then approaching the first hearing dispute resolution, the FUDRA, and then suddenly there's all this pressure on the mother. The court is coming at this from the wrong angle. The court is coming at this from why aren't these parents just getting on? Can we not just bang their heads together? And until the domestic abuse is proven to them, they are wrongly assuming that this is just two squabbling parents. They will stand down at this first hearing and allow duty CAFCAS officer, any representatives, so the solicitors, barristers, to have a chat with the parties, see if we can work something out. Yes, mother's worried about contact. How can we make it safe? Let's put it in a supervised contact centre for a while and see if dad can be a good dad with the children. However, I have several issues with this. Is it safe? at a child contact centre, in a 6-week period assessment, is it not possible that a highly manipulative abuser who cannot act like the doting father for 6 brief sessions, and in those 6 brief sessions can be all charming with all of the support workers, can be charming with the children, speak well of the mother, and all of the things that you'd expect a normal co-parent to do, a positive co-parent to do. And then the problem with this is that after 6 weeks of ticking the boxes and everything looking fine, the natural progression of the court is to move then from supervised in a contact centre to moving to supervised by family members to unsupervised contact. So here you can see a danger. A mother can be persuaded at the court to agree to some kind of supervised or child contact centre because everybody, yes, of course it's been domestic abuse and you must be terribly afraid. But let's think about the child's relationship with the father. And I fundamentally disagree with this point, because if the father is abusive to the mother, he will manipulate what goes on in the contact centre, and he will make sure that he behaves impeccably and moves the contact on. The parties are coming out of the court with some kind of staggered arrangement of increasing contact leading to overnights. And then as soon as the court's not watching, the abuse starts again, the manipulation of the children, emotional and psychological abuse of the children starts again. Even speaking badly of the mother in the earshot of children or to children directly is harmful to them. Practice Direction 12J, paragraph 3, has a very wide definition of the kinds of harm that can be caused by domestic abuse. And harm includes seeing or hearing the ill treatment of another. So if the children are going to daddy's for a day and then they're coming back really upset because they were saying really horrible things about mummy, and for a child that's terrible because they think they're half mummy, half daddy, so therefore daddy can't half like them. They become conflicted, upset, distressed. Younger children may start to show regressive behaviours. As a court user, if this is happening and if you're in some kind of contact having to happen state, keep a record of everything. Keep a diary of every contact session and of any issues that arise afterwards. If your child is struggling, speak to your doctor with your child and ask them to explain what the problems are. Speak to the school so that the school can watch for any changes in behaviour from the child when they have returned from contact. So this pressure at this first hearing is terrible, and this is my advice to the court user. You know if the contact is safe or not, and this is where you have to be really strong. You have to hold your position. The practice direction is in there. Look at my message to the family justice system and the fact that if you're saying at that first hearing, no, contact is not safe, then interim contact cannot be ordered until the court have made findings. You have to stand your ground. And this is the really sad thing, because you've got Kafkas trying to make you sort it out and be amicable. You've got the court disapprovingly telling you that you need to sort yourselves out and agree things, and you've got to co-parent forever. You've got the other side's solicitor or barrister saying the same thing, and worse still, some people have even got their own solicitors saying, oh, well, I don't think we should follow this up because you'll be accused of parental alienation if you're not shown to be cooperative. And that's not really helpful. So these poor mothers, vulnerable mothers coming out of an abusive relationship, confused, anxious, depressed, all over, in short, are being persuaded to agree to a contact that they know is not safe. So that's something that the family justice system is getting wrong as you come into the court. I said I was going to be blunt. There are some other things that the court users themselves are not doing, in my opinion, which helps them with their case. And it's understandable. The court user is approaching the proceedings with fear, anxiety. They've been bullied by the abuser. They've been threatened. There's threats to reveal alcohol use, drug use, mental health allegations. They're going to go for full custody, all of this sort of stuff. And because there is a very unhelpful wave of thinking that's emerging, which is that the court system is corrupt, then people start to hide, the mothers start to hide from the justice system. They don't trust the family justice system as they're coming into it. So they don't tell the CAFCAS officer that actually, yeah, they have got a bit of a drinking problem since they got out of the relationship. They don't talk to their GP about it. So then things start to get a little bit confusing for the court, because if this evidence comes out that they are drinking a lot, then both parents can be seen to providing misleading, inconsistent information, etc. So the mother doesn't come across well. As well as this, if they are also thinking that the system is corrupt, they may be coming across as aggressive or confrontational or hostile with the CAFCAS officer, with the court system. And that's leading me on to what you need to do and how you need to approach the family justice system. Well, this is my best advice to you. And I know it's really difficult to accept this, but the first thing is to know the process, that practice direction I keep talking about. Trust the process, even more difficult, and trust yourself about your own view about contact and whether it's safe. What I need you to understand is that it is not the family justice system necessarily that is causing all of the problems here. Completely agree, they've got to be consistent. See my other video. However, the other thing that is happening is that it's not just the family justice system, it's actually the abusive personality on the other side, giving their instructed solicitor instructions which you know are lies, which aren't true, okay, and they are the one that's making the allegation of parental alienation, saying that you're harming the children by stopping their relationship, because they will do anything to shift the blame or abuse for their behaviour from themselves. Okay, they will shift it to you. They will say that it's you that's causing the harm, not them. So that's the first thing that I want people to try to understand. There is a mechanism in place that can really help with child arrangements and domestic abuse. I need people to trust the process, feel calm with the process, and know that the problem is probably the abuser, not just the family justice system. And then other things you can do to help yourself stay clear in your position about whether or not contact is safe. If you do not think that contact is safe, you say, no, 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 hell no. The contact is not safe, and I'm not going to budge on that until the court have looked into my evidence, and then they have said, okay, we've seen this, we've seen the abuse, we think either it's not significant enough to stop contact, or that the abuser needs to do a domestic violence perpetrator programme, etc., etc. Then they may order indirect contact while that happens. But it's staying clear in your position and having the confidence to do that when you get to that first hearing and you've got your abuser, the C100 application saying that you're lying, CAFCAS telling you that you need to try and work out some contact, the other side solicitor telling you that you need to try and work out some contact, possibly even your own legal representation telling you you need to work out some contact, and the court saying the same, because they'd love it if we could all just get on and be perfect co-parents and communicate perfectly and put the child above this conflict. But you can't do that in an abusive situation. You cannot co-parent with an abuser, and that's why it keeps coming back to court. Again, see the message for them. Finally, how to approach the family justice system. Standard advice, again, very generalised advice, evidence. Communicate with your abuser in writing, so text or email only. And then you can also, I don't know if it's grey rock, grey wall, grey stone. Anyway, you can just ignore them apart from communications in writing, and then you have the evidence. Keep all of those. Talk to people, okay? Talk to people, take advice, take support, speak to the school, because they have a duty to assist you with the welfare of the child while they're in their care. Speak to the GP if you're concerned. Take your children to see the GP, because this can all add up to showing the picture of what's going on, which is that this relationship with this particular father is having a toxic effect because the abuse has not been dealt with. And finally, to assist you with understanding the process, the child arrangements, what should happen with, without domestic abuse alleged, please watch the other videos that we've got on the Survivor Diaries channel. I keep repeating, please watch also the message to the family justice system as well, so that you can see that this criticism that I seem to be making a little bit at litigants in person, at court users, that you can see that I'm making it just as bluntly, if not more so, to the family justice system. So please do watch the second episode, and once again, thank you very much for watching this episode of the Survivor Diaries, and I hope to see you very soon in episode 2. Thank you for watching, and bye.